going forward in relation to this application. Caroline, I know you asked for some advice in relation to this. So we've obviously got the application that is before us. We had the Licensing Standards Officer intervene in relation to this one, which for me is his comments in relation to the actual application. He has none, other than actually raising the fact that, you know, there was these standard terms and conditions. So what we have is a statement of licensing policy that was granted in 2023 in respect of any application that would come forward to a board. The expectation is the applicant would review those that document in terms of its application and be prepared for the board to apply any of those conditions, in particular the one in relation to home delivery, to this application. So from that perspective, there is no, we're not going to be hearing from the Licensing Standards Officer in relation to this in terms of any objections or confirmations that he may have in relation to this application. But in terms of the statement of licensing policy, that is a public document, and the expectation will be that the board can apply the conditions in relation to that policy to this application. So I'll hand you back to the chair in relation to processing the application. Thank you, Caroline.
Okay. Thank you. It's a very strange one this morning. Councillor Law.
Oh, you need to click.
Oh, sorry. I keep forgetting.
Thanks. I was just going to propose to move with the local licensing conditions for home delivery and the other ones that we've got applied.
Before we move to that, I want to hear from Ms. Lynn.
Yeah, Mr. She wants to make a presentation.
I'm going to give Ms. Lynn an opportunity. I'm going to give Ms. Loudon the opportunity to address the board before we move on. Ms. Loudon.
Yes, thank you very much, Your Honours. This is, well, it was a relatively straightforward application until about 40 minutes ago, but essentially all we're seeking to do is update the activities wording on the old Brig licence. I'm aware that you'll know this premises. There's been a real move to food to go type premises. The Costa Coffee's the takeaway side of things for Penny Petroleum, a real focus on that. And if you look on their website, a number of the premises that they're now operating might have a post office or a laundrette. They do national lottery, all that sort of thing. They do home deliveries, and of course the click and collect side of it as well. So what we've sought to do is essentially have one size fits all wording across all of the Penny Petroleum licenses across Scotland. So I've been lodging major variations for them all. And essentially that's all we're doing is making sure that the right activities are narrated as they should be on the licence. And it's as complicated and as uncomplicated as that. For the avoidance of doubt, I have no issue with the board's own conditions in relation to home delivery. We can meet them all. We operate through Just Eat, which is an online delivery format, and when the delivery driver arrives at the premises to deliver, if it is an alcohol delivery, they have to narrate and put in input into the site. They can the age verification essentially that they followed and make sure that the dates of birth all add up. So it's all electronically done, which assists with everybody, and nobody's left trying to do maths and work out ages, etc. So it is all there. They usually do a challenge 100 rather than just challenge 25 to make sure there is just no discrepancy at all. And of course alcohol is not left at the property if somebody's out, that sort of thing as well. So very happy to provide your clerk with a copy of that home delivery policy as well. It's written down for Just Eat, and it's as I say, it's part of the training and what Penny Petroleum abides by as well. So I hope that's all you need this morning, and apologies for the slight hiatus earlier on, but certainly no issue with the delivery conditions as they are. Thank you.
Okay.
Motion to grant with the local conditions for home delivery.
I'm happy to second the motion for the alteration with the application of our standard conditions for home delivery.
Members, are we happy with are we happy to accept it?
Yes, Chair.
Grateful to you. Thank you very much, Your Honours. Appreciate your time this morning.
Okay.
Thank you.
Okay. We're now going to move on to item 4.2 on the agenda. I believe Sean is going to introduce it. Before we begin, we've handed this information here this morning. We've been handed this information this morning. A member quite willing to accept this additional information.
Has Councillor Keogh been sent a copy? Because he's online. So he won't have seen it.
I'll send that just now.
As part of the paper, I realise that Councillor Keogh may not have seen this, but I believe that this is in addition to the paper in front of us. So I personally would just move to accept the information.
I'm happy to second that and accept the application and apply the standard conditions.
Well, let's go through the procedure first. Paul. Oh, sorry, Sean, did you submit?
Good morning, members. So, starting on page 23 of the agenda, you'll see that there is an application from Sasa Convenience Store. This is a non-minor variation which seeks to add home delivery to their operating plan. You'll see attached an application form, an operating plan, and a response from Police Scotland which made no comments, and you will see a representation from the Licensing Standards Officer. The board are therefore asked to consider all the information before them, and having done so, to determine whether to grant the licence subject to local conditions, or refuse the application. In addition to this, it's worth noting that Councillor Earl was already covered, but the applicant is unable to attend in person today, so she has submitted a letter for the attention of board members. Thank you.
Members have had a chance to look at the additional information that's been introduced.
Personally, I think that the submission covers a lot of points of what we would expect in licensing and shows a good understanding to my sort of first read. So I'd be happy to support on that basis.
Do you have any questions for Paul? Or any questions on his representation?
Sorry, I'll be very brief. You'll be pleased to know that I have spotted that there's home delivery on this application, it being the only matter that's being added to the operation. No concerns. I've engaged at length with the applicant, and her response makes it clear that she does have an understanding of what will be required in terms of home delivery. I will have nothing to add to anything that's in writing here, other than to remind the board that there's a very useful list of the local home delivery conditions in Appendix A, and would suggest that all of these conditions are in accordance with our policy, necessary and expedient for the purposes of the licensing objectives.
Members have any questions for Paul? Prepare for Councillor Lee, who's moved that we accept the paper. I'm happy to second it.
Okay. So just to clarify, move to accept the application with the inclusion of the standard local conditions, and that's, yeah.
Okay. And now we go on to application in the name of Lodge Ladyville. Now, I see from the further information that came in, that we should have had a representation from this applicant here, but has been unable to attend.
Yes, so just to confirm, the applicant for Lodge Ladybell is unable to attend today. He was hoping to come in via Teams, but he's been caught up, I believe. So this application is again a non-minor variation which seeks to convert the premises from a members club to a more general licence. You'll see that there's an application form attached with an operating plan. There's a response from Police Scotland which made no comment, and there is a short representation from the Licensed Standards Officer. The board are therefore asked to consider all the information before it, and having done so, to determine whether to grant the licence, grant the application subject to local conditions, or to refuse the application.
Yes, good morning. Just for clarity, there's the most recent communication from Michael Hempson, who represents Lodge Ladywell in terms of this application, is that due to sickness in his workplace this morning, he has been unable to join the meeting. However, I can perhaps on that matter put the board members' minds at rest. I have raised with Michael during the discussion of this change to the premises licence at great length. They've not jumped into it without considering all the pros and cons of the change that they're seeking to make. The premises are, as far as I'm concerned, well run, cause no difficulty to me from a compliance point of view, and certainly Michael and the other committee members that operate that club in particular are in regular contact with me when they're thinking about making changes or doing anything that they're not certain is within the terms of their licence, and I've always followed any guidance and advice. So to go to the application, this is one of the more unusual applications that the board have considered. We've only ever in Clackmannanshire had one other club that has made this step. There are many clubs throughout Scotland that have made the step from the status of a members club to what I loosely use the term an open licence. There are significant differences in the way that they're able to operate. Board members will remember from their training, I'm sure, that a club is only entitled to make sale of alcohol to its members and certain other categories of people who may visit the club, temporary members and guests. This club operated as a social club in that way, where they could only make sales of alcohol to their guests. The side of that causes the club a difficulty in its long-term operating plans is that it means that they can't rent out their halls, lease out their halls for events and things like that without the need for applying for an occasional licence, which then allows non-members of the club to frequent without the need for keeping records of visitors and books and stuff like that. So they've considered their operation. They operate solely as a social club, completely different, completely separate from the Masonic Lodge organisations that also occupy part of the building. The social club is a different entity altogether. Over the years, they've built up the popularity of the social club. They were very rapidly approaching a regular occurrence where they were using all 12 of the occasional licences that they were entitled to have in a year for special events. They also wanted to open their door as a community hub and do other things within the club that they felt would be much easier with an open licence. It changes nothing in terms of the sale of alcohol or compliance matters. It changes nothing whatsoever. They are still licensed premises that are bound by all the terms of the Licence in Scotland Act. So from a compliance point of view, it makes no difference. They will still have to continue to do the same things that they were doing. The key differences is they now have to appoint a premises manager, which is a person who is the holder of a personal licence, to authorise the day-to-day sales of alcohol and manage the day-to-day alcohol arrangements on the premises. That actually makes compliance much more likely rather than less likely, because at the moment they could be operating with volunteer staff that are trained to the basic minimum that staff are allowed to be trained, the 2 hours of mandatory training delivered out a book by somebody who's qualified to deliver that training. So there's a step up in the level of staff knowledge and training happening with the change. Now, in addition, they've sought to add an outdoor drinking area to the east side of the club. They own a significant portion of the car park. They don't own all of the car park, but the outdoor drinking area is entirely within the area that they actually own. It's relatively small. It's shown on a layout plan. It's not a massive area. I don't know if we've included if the layout plan's been included. I think that the plan that came in was too big for us to scan because we don't have scanning facilities for documents that size. But it measures, I think, from memory, and this is a guess rather from memory because I've seen it on the plan. It measures something like 10 metres by 3 metres from the building, and it may not even be as much as 3 metres from the building. If you're facing anybody who's familiar with the building, at the right-hand side as you're driving out of the housing estate, it's on that right end. They do have a proposal at some point going forward to put in, there is already an existing fire exit that opens out onto the area where the outdoor drinking area is. They plan to extend or install a large window so that they can have better supervision of that outdoor area. And I think the plan is to replace the fire doors that are there with a different type of fire doors that would allow visibility out into that area as well. The outdoor area is a reasonable distance away from adjacent housing. It is unlikely, in my view, to cause any concerns for local housing. And in any case, they have a legal responsibility to manage it appropriately without causing any nuisance to neighbours and things like that, which I'm sure they'll make best efforts to do. On the rare occasions where the summer weather allows, that the Scottish weather allows an outdoor drinking area to be fully utilised, I would imagine they'll keep it well under control. They have a good reputation in the area. They certainly, as an organisation, don't want to be tarnished with any record of bad behaviour. So I'm certain that the committee that are in place at this time will take great steps to manage that outdoor area when it comes into use. I have referred the board members to the statement of licensing policy as it relates to outdoor drinking areas. There's a significant list of conditions that have been historically applied since the latest rendition of the statement of licensing policy. I've reproduced from the significant list of the conditions that I think best fit and may be necessary and appropriate for the licensing objectives to be upheld in relation to this premises, and they appear in Appendix A. There is somewhere in the region of 13 separate conditions. I'll draw the attention to condition number 11 that requires the board to specify any notices that they may want to put up in relation to the conduct of customers, children, young persons' access to the area and permitted hours of use. My understanding from speaking to Michael is that they will put whatever appropriate notices up in any case that they feel necessary to manage the area properly. And I don't anticipate, I suppose, any difficulties stemming from the application and the change of operation. If I've got any questions, I'm happy to answer them. I have spoken to Mr. Ibsen frequently throughout the process, the changes that they're making.
Before we move on, Fiona, Paul, he touched on the proximity of the houses now around the proposed outdoor drinking area. As part of a good neighbour policy, do you know if the club has notified the neighbours round about of their intention to operate an outdoor drinking area?
They're notified as part of the application process, so there's a boundary notification process that the licensing board notifies a number of neighbours. I don't know specifically the ones that we notified, but I can confirm that there was a site that was put in place that also makes the notification, and that was placed out near the building in a convenient place where it can be read by anybody of interest. But I am also fairly certain, I can't say for 100% sure, but I'm fairly certain that I recall from conversation with Michael that the neighbours in the immediate area were all approached and discussed. In fact, one of the household closest to the building is occupied by the convener or one of the office bearers, I can't remember his role, the secretary for the actual social club as well. So I'm sure that they have taken great steps to make sure that neighbours are aware of the potential changes.
Okay, thank you, Fiona.
You wouldn't be so kind as to show me where it is on the map?
Of course I
That I can't, I just would like to see. So, got it.
Thank you very much. There's a code there.
All right, okay.
So,
Right.
okay, does that make sense to you now? So
Yeah.
it's a standalone building, backs onto the football park, of course, it's in the outdoor areas that take a portion of the car park to that right hand side.
Grand. Okay.
That helps.
Yeah, thank you for showing me that. So a couple of questions would be, in regards to the outdoor area, is that near kind of an entrance where people will be walking by? I'm just concerned about, I know obviously our policy says about second-hand smoke, but a lot of, I think, outdoor areas are near to the entrance. Oh, sorry.
The outdoor area is nowhere near, I suppose, in the scheme of things, the main entrance to the building. Although there is an entrance from the bar area to the outdoor area. The outdoor area will be by virtue of the conditions, because it opens on a public space that's bound by the public drinking bylaws. The outdoor area will have to be clearly delineated by a barrier, a physical barrier of some kind. You know, my understanding is that their intention initially will be to use airport-style barriers that they can take away, but in the long run they intend to build a more permanent physical fence to make it very clear where the licensed area ends. But it's not in the immediate vicinity of the front door, no.
Okay, my concern is that smoke obviously doesn't stop just because there's a wee fence and whatnot, and then if there is children and young people, then that kind of puts that they're not allowed to go outside because they'll be smoking in the outdoor area. That's my concern there. I was also thinking in regards to, I know you said it's a well-run place, so obviously it's been, they know their members, so they've got more control over them if they kick off, or they know kind of the personality. They can turn around and say to that person, you know, calm down, Jim, or, you know, your membership will be revoked. So obviously, opening it up to the public, we won't have as much constraint on the people that are coming in. Do we know if they're thinking about how they're going to kind of deal with that they've kind of not got that as much control over the people that are, or know them as well, as to how they'll deal with that? Just like I'm thinking the staff that are involved, it will be a bit of a different kind of atmosphere.
Yeah, I understand that concern. They are slap bang in the middle of a community, as you can see from the location. They're a very community-orientated use building at the moment anyway. I don't anticipate that would change much. They've run regular events in the premises under occasional licences, and events where they've run events that don't require occasional licences, where they've had invited guests that are not necessarily local to the area, you know, and there's no concerns been raised by either Police Scotland or to myself by any neighbours or anything like that. I know quite a few of the committee because of the amount of time I've spent discussing this application. They first discussed this in the summer last year, so they've not rushed into a decision. They first sort of made inquiries about the possibility in the summer last year. In fact, it was either presentations to the Coms in April last year, and it was off the back of the presentations that I made to the Coms in April that they approached and asked how to go through this process. So they've taken their time. They're quite a robust committee, is how I would describe them. They're all upstanding members of the community in the area. They're all quite well thought of, my understanding. So I can't imagine that anything is going to change in terms of the way they run the premises. And of course, if it does, you know, they'll be invited right back here, and what has been done can be undone. You know, there's no difficulty with taking sanctions on premises that are poorly run going forward.
Thanks, Chair. I was just wondering, Paul, in your investigations, if you know, in lieu of representation from the applicant, Is there any mention at all to the, I believe it's a gentleman's agreement with Bankery Primary School relating to the parking strike, which uses that car park in its entirety? I'm aware that obviously the addition of an outdoor area, along with the, I believe it's a council compound at the far end, would sort of eliminate that. Was that mentioned at all?
It wasn't, but the area where the outdoor drinking area is planned is genuinely, the scale of it, really quite small. So I don't think it would impact on parking because they're moving. I think they're planning to move an area that's got bins in it and stuff just now.
Or right,
That's right.
Yeah, we are now. Yeah.
You know, at the corner, I think they're planning to make some alterations to where the bins are stored. So the actual area of the car park that they're taking over, at very worst, would be a space that would probably hold, I don't know, 3 cars, at very worst. So it's not going to have a major impact. And all the times I've been there, I can't recall ever seeing anybody parked close to the building, and I've been there when that car park's had quite a few cars in it. I've never seen anybody parked in the area where the outdoor area is planned to be.
Okay.
So I would be surprised if it has any impact.
Right. Yeah, no, that's not it at all. Yeah, thank you.
Yeah, I have to admit, Paul, I'm struggling with this in the absence of a location plan as well. And one of the areas I'm struggling with, if they're creating an outdoor drinking area, would that not require planning consent? And then consequently, what comes first, chicken and egg, is it the planning consent or the licence? Do we consider these things separately? A bit confused about it, really.
Are you in the meeting? No, I was going to say, because we could have thrown a. I'm going to get Sean to join the meeting and we'll throw an aerial photograph up on the big screen. I think, can we do that, Mel? Screen share on the big screen. I wonder there's a technology that let us downgrade for this morning. That let us down this morning may help us just now.
Yeah, yes.
Just obviously Sean's got a lot of things open in the background. And
Fiona just showing me the area. It's in a completely different place from where I dropped a pin into 6 Bankery Place, which seems to be in the middle of a residential area. So that's what, but my question still remains in terms of planning consent first before.
Well, there's an aerial photograph of the building. So the building is the building on the top left-hand side, and you can see the car park area with the containers, I think, in the car park. So as you're looking at that building, the small area that is going to be utilised as the outdoor drinking area is almost in that shadow to the right-hand side, going right down to the bottom right-hand corner. It's basically literally the width of a couple of tables and 3/4 of the length of the side length of the building. In terms of planning permission, I actually don't know the answer to your question, but it's not a licensing matter anyway. It's a matter entirely for planning to deal with, and I'm sure if planning need to take some enforcement action that prevents the use of the outdoor area until it's been approved, then they will. But it's not a matter to be considered here today.
What's the normal? Is there a convention? I appreciate they're 2 separate pieces of legislation, but to my mind, the planning system has built-in neighbour notification, etc., and more consultation than, say, the licensing authority. So I'm just wondering if there is a convention in these sort of cases.
There isn't a convention, and I mean they're 2 separate statutory bodies that are making decisions. This one here is the licensing board in relation to the application, and then if the applicant and if it's deemed there's requirement for planning consent, they will need to then go and get their planning permission, as you rightly say, that they have to go through the whole of the planning process, whether that can be decided under delegated authority or whether it has to go to a planning committee, it will be for the planning authority to decide.
Okay, my other question, Paul, it's moving from a club effectively to more open facilities. So have they given an indication of when they want the drinking activities to occur?
There's no request to change the hours that they currently enjoy, or any of there's minor changes to some of the activities, I believe, but there's no request to change anything of any significance, but there's certainly no request to change the hours that they currently enjoy.
Okay, thanks.
Members, have any other questions? Yeah.
No, I was just going to propose to move and grant the licence with the local conditions. I was just going to say that I attended the Fife Licence Board a couple of weeks ago, and there was quite a few, I think there was a golf club there that was doing the exact same thing, so I think this is becoming maybe the norm for these types of clubs in order to try and help them kind of survive. So I think this will be the first of maybe many, although we're not that big. But no, I'm happy to move these just with obviously what the licensing officer said, and obviously for adding in the draft local conditions regarding the outdoor drinking area.
I'm happy to second that. After question and answers, I'm reassured with what's been proposed here, and I'd like to second the application.
Do members agree?
Agreed.
Yeah, same with the centres.
Can I just seek clarification? I think one of the things that in terms of the conditions that the licensing standards officer had raised was in relation to the signage to the area. The notice is prescribed, so I just want to double check that you're happy that what has been proposed there in terms of the signage around noise, conduct of customers, children's and young persons' access to the area and permitted hours are what you're actually asking to have. Thank you.
We now move on to the final item on the agenda.
Hi everyone. So the final item we have today is in relation to the personal licence held by Mary Puspa Deshanth. The applicant, or licence holder, sorry, was provided the documentation in relation to this item, and it relates specifically to a finding of conduct which is inconsistent with the licensing objectives. The LSO has provided a short covering letter or summary in relation to this item, and the options that are available to the board today are to revoke the licence, endorse the licence, or take no further action.
Paul.
That's good. Good morning. Not a great deal to add to my submission other than to remind the board of the previous events. There was a premises licence review application in relation to a shop premises in Alva that Mary Puspa Deshanth co-owned and worked in along with her husband. A number of events took place in relation to that premises, and a number of findings were made in relation to that premises, which resulted in her husband's personal licence being revoked and the premises licence being revoked. Not least, the event that occurred was the sale of alcohol to a 14-year-old on the premises. There's no suggestion whatsoever that Mary Puspa Deshanth was involved in that particular action. However, the aftermath of that was that her husband appeared at Stirling Licensing Board as his personal licence had been issued by Stirling Licensing Board, and they suspended a licence belonging to him pending some further inquiry that they were making in relation to his licence, and that suspension took place on or around the 10th of September, I understand. There was a request as part of that the applicant engage with his local licensing standards officer. I visited the shop and as part of that process, having been made aware of the goings on at Stirling on the 12th of September, and found on that day an individual who you can see is named on the training certificate at Appendix A, called Joju Noel. Joju was an Indian national here on a student visa, and spoke very fluent English with a clear understanding of his role in the shop. However, was absolutely certain that he had not been trained in relation to licensing matters on the 10th of September, the date that appears on his training certificate. He indicated that he had had some training many months before when he first started working for them, but it didn't account to the matters that I discussed. It didn't amount to the matters I discussed with him, that he should have been trained in the 16 points that are contained within the training regulations. He was quite certain that he hadn't been trained in most of those matters, although the concentration of his training had related to age verification, which is perhaps one of the more important aspects, but the other matters are equally as important. He conceded that he had in fact written his name, not signed, or written his name and signed the training document at some point when he had come into his work earlier that week. But that was not at the point when the training was delivered, and he was absolutely certain about that. Unfortunately, the process went on at the hearing. Just trying to find the date, the hearing last year, where during the course of the premises licence review application, this board made a finding that the conduct of Mary Puspa-Dishant in relation specifically to this one matter was inconsistent with the licensing objectives. That decision has been made. We don't need to revisit that matter. The decision has been made. It's now a matter to determine what disposals the board members would wish to make in relation to that decision that was made. Mary Puspa is entitled to be heard on that matter before the disposal is made. She's entitled to be given the opportunity to be heard, which we've made every effort to. I can confirm that the information I have as recently as last week is that she still stays at the address that we've been corresponding with. It would appear that the email address that we have is still active. We're not getting any obvious error messages to say that the email address doesn't exist. The shop premises is apparently closed and has been for a few weeks now, according to those around the neighbouring shops. And finally, the last piece of information that may be useful to the board or not is that when I last spoke to Mary Puspa-Dishant when I visited after the revocation in relation to another matter, she was still working on the premises, but she was heavily pregnant, and my memory, and it is very much a vague memory, is that her husband explained to me at that time that she was due to give birth in February, which perhaps could explain her absence today if she is so heavily pregnant. I don't think there's anything to add other than to submit my report to the board and ask the board to consider what action, if any, is necessary in relation to Mary Puspa's personal licence. And obviously the options have already been explained, that you may take no further action, revoke or endorse the licence in relation to her conduct.
It was just the clerk in regards to, obviously, the LSO said that, that Mary Puspa is, she should be heard. Obviously, they've written to her, tried to email. Obviously, we've not heard back. Is that, because we've obviously reached out to her and we've not responded, is that enough to say that, you know, we have kind of fulfilled that to try and get her to be represented? Because obviously if she couldn't make you in person, I suppose you could write a letter like the previous case has done. So I just wanted to make sure that, you know, all kind of reasonable steps have been taken to ensure that she was represented before obviously we decide whether to continue or possibly defer on that basis.
Thanks for the question. I'm going to speak to my colleagues and ask them, Sean and Leslie, and whether or not what communication was made with the individual in terms of this review that is taking place just now. I'm assuming email. Did we try and telephone her? Yes. Did we do any letters to her?
So we had previously corresponded via email, so we sent the documentation out by email in the first instance, and it was also posted out as well.
Have we ever received any reply from her email before?
Check. It was the email address that was provided on her application form for a personal licence. That was received, I believe, last summer. So it wasn't as if it was a licence that had been granted 10 years ago. She'd only had the licence for a few months, and that was the email address we used for correspondence.
If it helps, I personally spoke to her in, I think, December, when I was in the shop, to make her aware that she would receive communication to attend this board hearing. So I physically actually spoke to her in the shop in December as well.
I suppose in answer to your question, I think we've made all efforts to the individual to contact them with a view to allowing them to represent themselves in relation to this.
Yeah, I was just going to say move to continue, obviously, with the hearing and that basis. I just wanted to make sure that, you know, she had been contacted and for that to be on record, because obviously, I mean, I personally would like to speak to the people involved, but I think we have made all reasonable steps in order to contact the individual, and as Sean has said, that, you know, that was a recent email address. It wasn't something that's been sitting there years in the cabinet is a recent one. So I think I just wanted to make sure that that was, for us moving forward, that was on no.
Mr. Lawyer, you're absolutely right. I mean, I firmly believe that every person coming to the board should be given the opportunity to address the board and to answer questions that the board may have. I'm happy that all reasonable steps have been taken to contact this person without any result. I mean, Paul has indicated there that the woman was heavily pregnant. She may just have recently given birth. That doesn't stop her fingers operating a keyboard to contact the licensing board, the licensing authority. There is no excuse for not doing it in this instance. I'm also aware that at this time of year there's a lot of religious festivals go on at that time, and that may have one of the reasons it may be that the shop was shut, but we don't know. We don't have anyone here to answer that question. I believe that what we have to do is make a finding based on the information that we have in front of us just now. I believe there has been sufficient time to do it, and I think that looking at the evidence and listening to what has been said by the licensing standard officer, I'm prepared to move that we revoke the licence of I can never remember her name, Mary Pusser Deschamps, effective from today. Before we do you have any questions? No? John?
There's just also, obviously, we've got the account of our licensing officer when we spoke to the person that was employed, and obviously we've got the written evidence. So for me, that is that I just wanted to just double check with the clerk, because obviously, and just to reiterate, the licence board, we work with probabilities. This isn't a court of law, so it's not that, you know, we have to have that kind of I can never say it, collaboration. It's such a difficult word. So I just wanted to make sure, just to confirm that we are working on the probability, but although I think the probability here is very backed up by the account that we have from our licensing officer, and in relation to the document as well, that it does look like it was falsified, or there's a high probability it was falsified.
Yes, so this isn't a court of law, it's, you know, it's the licensing board, and it is on the balance of probability for the board to be able to make that decision.
On that case, I'm happy to second that. I don't think the licence holder is a fit and proper person if they have what looks to be falsified, a high probability that those documents were falsified, and the consequences that could have on somebody working in a shop selling alcohol and not adhering to the board's objectives.
Was there any other comments to make?
Just can.
No other comments?
So just to confirm, the board are looking to revoke the licence of the personal licence holder in this hearing that we're having, and on the basis of a fit and proper person because of the falsification of the training records. Is that correct?
That's great.
Thank you.
Okay, and that concludes the business for today. Thank you very much for your attendance.
Thank you, Chair.
Well, minutes to sign.